So anybody who's, I guess, who's watching right now, just so you know, on our Facebook page, we are working on a couple resource pages that we're going to be posting on there that have links to all of this information for the government. I mean, the hard part right now is we've been hearing for, I guess, weeks that help is coming. We just haven't seen into the questions because they're starting to pour in.
Yes,
so
I see that.
We've got a question. Yeah, we've got a question here regarding as an agent, if they've sold a house that was tenanted and the tenant signed an N11 form as well, it closes on, let's say, as of right now, in this example, it's June 30th.
Right.
Now the tenants are saying they're to. What can a seller do in this situation? I mean, the question is, I guess, probably more so, what if they can't find a place? What's going to happen?
So this is something that I was thinking about in the last couple days leading up to this, video chat. The reality of the situation is, in the province of Ontario, unless you have an order from the Landlord and Tenant Board evicting someone that has sheriff provisions, you can't do anything, right? So there's a whole process that you go through. And when this pandemic came about, the sheriff is not enforcing in orders. So even if you have an active live eviction order right now, the sheriff is not enforcing them. And then the Landlord and Tenant Board stopped conducting hearings. We're almost going on 2.5 weeks. And then they also implemented that they're not writing eviction orders. So anything that maybe you had a hearing leading up to this and you did obtain an eviction order, unless it's an emergency, so things they're deeming an impairment of safety, like things they're deeming emergencies are things like impairment of safety. I haven't seen any orders flow out of that right now since this has happened, but they're not scheduling new hearings and they're not writing eviction orders. And so the concern for anybody that's selling or purchasing a home that has a tenant in there, the reality of the situation is you're going to have to be extremely practical. You're going to have to be open to the ideas of, there's going to have to be an extension of the closing date, because if the purchaser is purchasing the property for their own use, the reality is that even if the appropriate notices were given or the tenants agreed to move out, the Landlord and Tenant Board just isn't writing eviction orders right now. And so without that order, you can't just move in, because what are you going to do with the tenant, right? Yeah. So you have to kind of be
well, you might have a new roommate.
Or that's true. You could certainly see if they'd be willing to share the living accommodations. So you have to think about maybe extending a closing date in light of the circumstances. Again, having open communication. So the seller, maybe there's some discussions with the tenant, a potential buyout to ensure that they're meeting their requirements under the agreement of purchase and sale. But the downfall for that is that a tenant doesn't have to agree to it. And then setting all of that aside, if you've purchased a home and there is a tenant in there and the closing date comes and goes and you don't have the ability to enforce or go to the board because you've given the appropriate N12 notice to the tenant for purchaser's use, then the reality of the situation is once the closing date comes and goes, you now have to switch hats and you're now a landlord and you're bound by the requirements under the Residential Tenancies Act, rent, maintaining the property, ensuring that the property's, complying with maintenance standard, health standards. So it's something, again, that's right.
It's just a big pickle.
You have to be flexible on this circumstance. So, it's something I think as a seller or a purchaser, you really have to have an open mind about the reality and being flexible for a closing date, the reality of potentially now becoming a landlord until the dust settles and you can move forward so that you can actually, go forward and move into the property. So it is something that is a lot of people have to be aware of right now. If they've already signed an agreement of purchase and sale, or they're considering purchasing a property that has a tenant in there right now.
Okay, so let's move on. We got another question from Kim here. So what if you have a guarantor signed? So let's say more student rental would probably be the example here. So you have a student rental where you have parents as guarantors.
Mm-hmm.
Can you talk to the parents about a payment plan? Is that appropriate? Do you have, because they're a guarantor, are you allowed to have that conversation with the parents, or do you have to go to the actual tenant?
So the first thing is that you always have to be mindful of privacy laws. Okay, yep. So just because someone has signed a guarantor agreement with, based on a lease agreement and with a tenant, certainly they are liable going forward for non-payment of rent or damages, and certainly they would be responsible in the event of a default. Going after a guarantor is a little bit different than going after a tenant, because the Landlord and Tenant Board doesn't have the jurisdiction to order money against a guarantor. That becomes sort of a small claims court matter to bind them to their obligations under a contract. But certainly, again, what I said when we first started this conversation, having that open communication with the tenant, and especially you referenced a lot of times guarantors come up for student housing and student rentals. Certainly approach your tenant and have that open communication by saying, is there a way that your guarantor could be able to assist you, and do you authorize us to reach out to them for seeing if they can assist in payments, repayment of that information? At the end of the day, if there is a guarantor on there and you're looking to recover rent, certainly you can always send a letter to them saying, we're not getting paid, you have obligations under the lease agreement, but there is that little bit of liability that, you always have to be mindful of those privacy, privacy laws and information.
Okay, so got a question here from Dan. Although the process can't be exactly be executed as normal, would you recommend landlords proceed with normal paperwork like an N4 on April 2nd, so you have a paper trail, or will none of that matter at the end of the day when this is all done?
So I think there's nothing wrong with issuing an N4 right now, but if you issue an N4 and the tenant doesn't move out or they don't pay, you could file an application, but again, there's no hearing dates they are assigning hearing dates right now, or they were a while ago, but we now are 2.5 weeks into entire dockets being canceled. So all of those hearings have to be rescheduled. There was already, probably anywhere between a 30 to 90 day waiting time to actually get a hearing date. So I would not sway people from issuing an N4 notice, but what I would recommend is that be accompanied with some type of communication, letter, email saying, you haven't paid your rent, here is the N4, but given the circumstances, we're willing to work with you. Please reach out to us so that we can, in light of all the circumstances that are going on, work together. And so you are, when everything goes back to normal, whenever that is, you've started the process. So you can at least file if someone hasn't adhered to the payments that they promised or the dates that they promised, and you're a little bit further ahead. But I think the first step, in light of all the circumstances that are going on right now, that there first be open communication. Now, having said that, if a tenant is a few months in arrears and they're in arrears prior to all of this transpiring, I think I think starting the N4 process so that you've at least started the paperwork so that when you can still file, but when the board starts scheduling hearing dates again, you're a little bit further ahead.
Okay. So what I'm kind of hearing, I guess, depending on the situation, and let's just say it really is a loss of job because of this pandemic.
Right.
Hey, everybody on this, watching this in the future, whatever, tenant, landlord, doesn't matter. Let's all be human. I think that's the big thing, is that we need to, more than ever, I guess what I'm hearing from you say is we need to act reasonable and care about each other.
Right.
Right. I think that's kind of like one of the big undertones that I'm hearing here.
I think more so it's not necessarily just that, because at the end of the day, everybody's running a business, right?
Well, yes,
And so,
yes.
but I think you have to take, in light of the circumstance, a practical approach and be practical about it, because we don't really know how this is going to impact going forward. I mean, even if, best case scenario, the board is up and running again and, everybody's back to their day-to-day routines and back to being employed and there's finances coming in. I think it's a little too soon, but I think that what we're looking at is this is going to go on longer. It's not going to come to an end in the near future. But the reality is, when and if it does go in front of a landlord, an adjudicator at the landlord and tenant board, they have to, in accordance with the law, factor in personal circumstances. And I think, again, I don't know how the board's going to approach it, but based on my experience, I think that that's something that's going to be heavily factored into tenants requesting payment plans. I think landlords are going to see that the board is going to start implementing lengthier payment plans than maybe something that you're accustomed to. I think that, again, if you can demonstrate to the board that during the course of this, you took a practical approach, you wanted to work with everybody based on their personal circumstances, I think that also assists you if they don't make payments, if you ultimately end up having to go to the board, when the board balances out the prejudice between the parties, you as a landlord have had open communication and done everything that you could to assist them in light of the circumstances that are going on right now.
Cool. Okay, thank you. And so let's keep moving on because questions keep rolling in. So we got Joe. What are your suggestions for landlords who are charging an all-in monthly rate? Landlords may be able to defer their mortgage payment, but there's no mention of utilities or property taxes being deferred. Any input on that?
So I think that I thought I read something recently that there is potentially some consideration about the government deferring property taxes, but don't quote me on that. The thing is that when you've got a lease agreement and it's an all-in situation, the rent is what it is, right? You don't have the ability to carve out, the utility component. So certainly if you have a situation where a landlord, again, you mentioned they might be able to defer their mortgage payments. If it's something that they're responsible for paying the utilities, that may be, hydro, gas, whatever the utility organization is, they might start implementing or working with people based on those circumstances. So I think in light of everything that's going on, everyone is going to have to turn their mind to the fact that they're not going to get payment in full, if at all, and there has to be, open communication, and every business is going to have to work with people in order to get payments.
Yeah. I know one thing out in Thames Centre, so anybody who's on this who doesn't know where Thames Centre is, if you look on a map where London, Ontario is, it is the municipality that's east of London. They have actually I guess, put a freeze on water bills and property taxes.
Right.
What they have come up with is that they will be due with no interest on the last day of the following month when their municipal office opens. So I mean,
Right.
that
So
could buy an extra month
I think you're going to see
or two, like
something.
up in the air.
Right. I
I
think
think
you're
they
going to
have
see,
to.
yeah, I think you're going to see something like that because again, you know, if we're talking about this business in particular, rental housing, if unfortunately because of personal circumstances, a tenant can't pay the rent, landlords rely on that rent in order to pay property taxes, utilities. There has to be give and take, right? So I think we're going to be seeing that quite a bit. And I know, again, we're 2.5 weeks into it. So I think as we go along, the longer this goes on, I think that we're going to see a lot more municipalities doing those types of programs. I mean, I just don't see any other way that they can go around that.
Yeah. All right. Another question here. We got Eric. Hey, Matt, business rentals. Any loans coming for business renters, and what can business tenants currently do? Have you heard of anything?
So I know that I mentioned the federal government has the Canada Emergency Response Benefit. I believe also that they're offering a 75% wage subsidy for small to medium businesses. And I think that there's funding available for that as well. But again, this is something that'll be available on, it's a federal funding. And so I think, again, I think it's going to be up and running sort of the beginning of April. And whether or not you qualify, they are taking measures to recognize smaller businesses, medium businesses, to subsidize certain wages to keep people employed. So that's something that I am aware is available as well.
Okay. So again, everybody who's listening, we're going to be posting as many resources we can on this on our social media posts. But also, if anybody wants, you can just send us a DM, and we'll send you everything we've got or that we're working on. So we're going to move on to another question here from Bradley. So if we haven't heard anything to the contrary that April rent should be forthcoming, would you recommend letting sleeping dogs lie or reaching out proactively? We believe in being proactive, but also don't want to give anyone any ideas they may not have already had. Any advice?
I think in this circumstance, I think you have to be proactive. I mean, if you don't have that communication, and as I said earlier, you know, some people may not feel comfortable approaching a landlord based on their financial situation. So I think given the fact that everyone is dealing with this, you're impacted in some way or another, taking a proactive approach is probably better than just sitting back. You know, again, we don't know how long this is going to go on for. We don't know how long the board is going to be shut down. We don't know how long there's not going to be any hearings. And so taking that proactive approach and maybe having that communication with your tenant or tenants may benefit you in the long run, as opposed to not saying anything and then now you're 2, 3 or more months in arrears because you haven't had any communication.
Okay, good advice. Message or question here from Carol. What about N5s continue to serve as required?
We do recommend that you still issue N5s. Having said that, again, because the board is accepting applications, they're not conducting hearings, and no eviction orders are being written. If there are ongoing issues, certainly you don't have to jump to an N5. There's nothing in the legislation that says you do. So maybe you approach something by, for example, if we're talking about it's a building that it's non-smoking and you're having complaints about smoking. I mean, the reality is there's probably more people that are at home than before. It is a stressful time. maybe approach it in a different fashion. But even though everything's going on, as a landlord, you still have all your obligations under the legislation. So one thing that's been coming up quite a bit is anyone that has deemed under the criteria of the government that they have to self-isolate or they're quarantined and they're still going in common areas using laundry rooms. That's been a big concern for landlords, because not only do they have a responsibility to other residents, they have a responsibility to their on-site staff. We're dealing with two totally different legislations. So I think in light of everything that's going on, I think that you have to assess it on a case-by-case basis. There's also, you know, a lot of people, it's hard being isolated at home. It's hard to be, you know, remote accessing. And so people are not adhering to the social distancing. So they're having 2, 3 friends over, let's have a cup of coffee, let's, you know, maybe have a glass of wine on Friday, and that is potentially impacting other residents. So I think you have to assess each situation, and if it's something that is serious, then I think that it would warrant doing the appropriate notice, whether it's an N5 or an impairment of safety, because you have to meet those obligations. But again, you have to make the appropriate business decision as to where or why you're doing it. Because if it's just a matter of someone, you know, is too loud or their TV's too loud and you issue an N5 to them, well, you know, if they don't stop the behavior, you can file an application, but you're not going to get a hearing date. So it might be better to start by saying we received some complaints that your TV's too loud. So I think you have to assess it on a case-by-case basis. As of right now, the board across the province has canceled all in-person hearings. So there's no hearings being conducted. They have conducted telephone hearings. And I think that we're going to see that they're going to be doing more telephone hearings. I don't know what that looks like, because if they're going to be conducting telephone hearings, my thought is it's going to be gravitating more towards monetary amounts and not evictions, because they can't write eviction orders now anyway. And there's no criteria. There's board policies on how long they should take to get their orders out, but there's nothing set in the legislation that says they have 10 days to write an order. And if there's an eviction component to it and they do a telephone hearing and they can't write that order because, you know, standard amount of time is 11 days. If a termination date is passed, it's 11 days from the date the order's written. And if they can't write an order for eviction, I don't know how they would be able to do a telephone hearing. So I think you're probably going to see things to start off with, which are tenant applications that are dealing more so with issues in their unit, monetary amounts, landlord applications that maybe they're dealing with non-payment of rent with no termination component to it, just an arrears only application, and then possibly anything to do with damages. But there's nothing that has been set out from the board. There's no criteria, but that's where I think that maybe we're headed until such time as the board is up and running again.
Okay, which, I mean, realistically, this could create a backlog 6 months deep, right? Like, I mean, who knows? Like, if it's already, you were saying 60 to 90 days behind already, and then you throw this in to try and figure out how to do everything. I mean,
right. So prior to this all happening, it really depends on the type of application that you file. The board, certain things, impairment of safeties, tenant applications where there's an allegation that they've been locked out or something to that effect, or the landlord's discontinued the utilities, they will take a priority over other types of applications. That's the board's internal policy. But the reality of the situation is, before this even happened, the landlord and tenant board was very short-staffed. There was a shortage of adjudicators. we were finding that right before this happened, because of that shortage, it was taking longer in certain areas, certain municipalities to get hearing dates. They were trying to come up with alternative solutions to address the fact that maybe there just wasn't an adjudicator available. So there was already somewhat of a backlog. And now, if you, I'll give you an example. I'm going to speak about London. I cover pretty much Ontario, but in London, the board sits Mondays and Tuesdays. Sometimes they'll sit on a Friday. A Monday morning, they call it a block hearing day. And a block hearing, the morning, is nothing but non-payment of rent. And you could be easily see anything between 50 to 70 hearings on a Monday morning. So we've now gone past 3 of those. And then you have the afternoon, and then you have Tuesdays. And that's just in London. You know, other municipalities, they don't sit every week. They sit maybe every second week, every third week, once a month. But, you know, this is something that I haven't heard how they're going to address it. I know that they're, again, trying to schedule telephone hearings. But at the end of the day, not only are those hearings going to have to be rescheduled, but there were applications that were filed prior to this that still have to be processed and scheduled for hearings. Anything that potentially was adjourned before this, you know, I really don't know what it's going to look like as far as timing on scheduling when the board's up and running again. I think that they're I know they're actively trying to figure out how they can keep the momentum going, how they can still continue to conduct hearings. It is very difficult to conduct telephone hearings. You know, you've got
well, how would they know they're speaking to the right people?
Well,
that's the first thing that goes to my head is,
well, right? They don't.
I mean, you
right?
don't.
You don't. And so, I mean, yeah, if it's a hearing itself, I mean, you know, if there's an adjudicator involved, you know, you are required to tell the truth. And so they would have no reason to believe that it's not the person that they said it is. But, you know, having telephone hearings poses many problems because one, it's difficult to have multiple people talking, you know, and it's also difficult because if anybody wants to rely on any type of documentation, maybe not everyone has access to a computer that they can scan anything in and have that in advance. So it does pose its own problems and hiccups, but I think that they really are actively looking to keep it going, and really that's the only choice that they have. So I don't know if the board is set up or if potentially they have the ability to do video hearings. That may be something that they look into in light of what's going on right now, but it's just something that we're kind of waiting to see what happens at this particular point in time.
Any kind of timeline you think that it'll take for them to figure it out? We talking days or weeks?
You know what? I don't know, because at this particular point, there hasn't even been anything that has been set in stone as far as when they're going to start conducting in-person hearings. Okay. As of right now, you don't even have the ability to file an application in person. So you either have to fax it in or you have to e-file a document, if e-filing is an option, because not all applications are readily available by e-filing. So those are the only options right now. And I don't think anybody really knows. And if we look at just how this has been sort of coming about, I mean, just businesses alone, you know, they were open and now they're implementing how many people can be in a store at one time if it's an essential business. So things are changing on a weekly, almost daily basis. So I think they're doing the best that they can, but I just don't think right now they have any sort of concrete time that they can say this is what's happening or whatnot.
Okay.
I will say, as a little plug, that since last week, our firm, we have quite a few landlords that, lawyers and paralegals that practice in this area, lawyers in real estate, and we are constantly and have been actively sending out memos and putting out bulletins about what we hear from the government, what changes to the legislation, funding available, practical measures that landlords should be taking, not only for non-payment of rent, but how do you continue your essential business because your obligations still go forward. So all of those, we send them out. We have an email mailing list, but if you're not on that email mailing list, all of the information is available on our website, and there's quite a few of them that have dealt with government funding.
What's the website? Is it just like Cohen? Just I guess Google Cohen Hiley. It's Cohen Hiley, and it's pretty easy to find then, or
yeah, it's cohenhiley.com. I apologize, my dogs are trying to participate in this right now. Right. Cohenhiley.com, and there is on the top of the web page, I think there's media information, it's called, it's a media tab, and okay. All of any articles, bulletins are all listed on there, and there is one that is specifically about the virus right now and all the information that we have been sending out to clients and different organizations on how to maneuver through this time right now.
Mario says he has tenants who are collecting disability pension who are now of the impression they do not have to pay rent. I've told them they are still obligated to pay because they're still receiving their pension. I've persistently reached out to them, but they will not respond. The tribunal is basically closed. So any advice?
So there was, I think, not intentionally, when the government started doing their, media press releases, there was one that went out that said, don't worry about paying your rent. And I think it might have been misconstrued that, great, we don't have to pay the rent. But the reality of the situation is that rent is going to be due and payable. So I think there's going to be consideration. I think that, the government has funding available to people, that there's going to be some type of lenience, whatever that looks like, to repay any amount that is owed. But it is a debt. And so once everything clears, that money, there was nothing ever intended to say that you are not required to pay your rent in this circumstance. It's just that people may not be able to pay their rent right now.
Just as a landlord, it's probably just keep reaching out
That's right. And, right. And so the situation is that if anybody's on some type of fixed income or subsidized income, there's nothing that, that's all made up of, a percentage for shelter, percentage for, basic needs. But unless the recipient directs the government to pay it directly to the landlord or pay it directly to someone, they will receive the funds. And so you can't approach, disability or Ontario Works or any of those organizations as a landlord and say, I'm not getting my money, you have to pay it to me directly. It just doesn't work that way, right? Yeah. But at the end of the day, to answer Mario's question, if they don't pay their rent, they don't pay their rent, but it doesn't mean it's not due and payable to him. So there will be a snowball effect that happens after everything settles, that will have to be paid back somehow. And, that's the reality of the situation.
Okay, so we also got Andrew here, his questions, his question, will a commercial eviction be enforced right now?
I don't think anything's being enforced right now. I mean, the sheriff's not enforcing anything. I think, you know, obviously the landlord, pretty much all tribunals have been shut down. It's not just the landlord and tenant board. They've been across the board. I think the courthouse, especially in London, was shut down. I know that they are reopening, but it's on, I think it's limited access right now, or they're only letting so many people in. So everybody's sort of in limbo right now, because even if you're lawfully entitled to do something, if you have an order or if you can move forward, there's just no measures to be able to enforce it right now.
Okay. So we also have Nate asking a good question here. What would you suggest for landlords that rent to students and are asking for the lease to be deferred to September due to social distancing and their school being closed? Their argument is that there is no school on campus and they have to move in with other roommates they have not lived with yet. Distancing is in effect.
So that's an interesting question, because they've signed a lease agreement. It is a contract. It's a binding contract. You know, but again, if they don't move in, they don't pay their rent, you have a means to go about dealing with it. Again, as I said, you don't necessarily have to jump to a notice that says you're evicted if you don't pay this amount, right? You can certainly file an application for non-payment of rent only and obtain an order for arrears, but until the board is up and running, you're not going to get that. So I think you have to look at every case on a case-by-case basis. I think in light of the circumstances, again, it just has to be practical, but also recognizing that, you know, this is a business that, you know, you entered into a contract, your business is based on receiving that rental income. You have bills to pay, you have overhead, and so just having that open communication with them and making that decision. Maybe you work with them. A suggestion would be, no, you're responsible for that rent. However, we'll work with you to repay that amount over some time in light of the fact that you're not living there, or some consideration given for that. But there's really no requirement to do that. It's just a matter of assessing each situation based on the needs, what's being said, and what you need and what your business needs based on that.
Okay, so we got a question here from Krista. We have a tenant who receives Ontario Works assistance and is refusing to pay any rent on April 1st because Doug Ford told her not to, and then we have in quotes her words by text. She doesn't believe she owes it at all. What approach would you suggest in this situation?
So it's nice that she got a direct quote from Doug Ford saying, don't pay your rent. But I think I touched upon that earlier. I think initially there was, and I think that there was another media press conference after that statement to sort of deflect the fact that, no, I wasn't saying you're not responsible to pay rent. You are responsible to pay rent. There's just, you know, consideration going to be given. So I think this is something that a lot of landlords are going to encounter. I would suggest maybe communicating in writing with a tenant, maybe by email, maybe by just a letter that you send over saying that you are required to pay your rent. We understand in light of the circumstances, please reach out to us if we can assist you, or we can work together on repaying this amount. If someone is flat out refusing, that would be a situation, and I think it was Dan that said, what about issuing an N4? Maybe if they're being that confrontational already, saying, I don't have to pay my rent, that you accompany that letter with an N4 by saying, we're not coming forward to enforce this. You are responsible to pay your rent, but in light of all of the circumstances that are going on, we'll work with you in, based on your financial income. I think a lot of people, especially if you're on a fixed income, and they have maybe their partner or someone else that's lost their income, and it's the people are just going to panic. They're not going to readily want to give money away if you're at home and you don't know what's going to happen. And so I think you're going to have a panic. But having said that, there is the requirement to pay rent, but landlords are just going to have to see the reality of the situation, that some people may not be able to do it. They may not be able to pay it in full. Some people are going to be like that particular tenant that's saying, the prime minister, or not the prime minister, but Doug Ford said, I don't have to pay my rent. So you just have to make sure that you're communicating with the tenant by saying, yes, you are still required to pay it, but contact us if you're having some financial issues, and let's work together on continuing to have rent paid.
Okay. So we have Nicole here. In terms of rent forgiveness to pay rent in full, is there anything the government mandated to offer relief, or is it all at the discretion of your landlord in order to determine it, if you can defer rent payments?
It's at the discretion of the landlord. I mean, the government has pretty much said that there's going to be consideration given to people. They've said that. And it first came out, don't worry about paying rent, but there is going to be consideration given. What that looks like as far as if tenants don't pay, what type of orders are going to be issued, what, if anything, the government then comes back and says something. We don't know at this particular point. So I think you have to look at it from your business, the conversations you're having with the tenant. The government, again, has implemented that emergency benefit fund that tenants can access if they're having hard times. As of right now, they can't apply to it. But it's something that is just going to have to be assessed. A lot of landlords, larger landlords, have been very much willing to work with their tenants. They've even sent out letters saying we're willing to defer rental payments based on your income, based on your personal financial situation. But that's just communication with tenants saying, we want to work with you, so reach out to us and how can we work together?
Yeah. We have a question here from D. What guidelines are there for interest charges on deferred rent, or are there any?
There are not.
Okay. Azhar is asking, what justification renter has whose income is not impacted as they are receiving OW or disability benefits from the government and then refuse to pay April rent?
I think we've already touched upon that with an earlier question. I mean, if their subsidized income is not impacted by this, then the reality is the rent has to be paid. So at that point, you make the business decision whether you work with them. If they're just flat out paying it, you start some type of process. But again, you're really only starting the notice process and then potentially filing an application. But right now, who knows when you're going to get a hearing date.
All right, so we got a question here from Jeff, and it's considering the landlord-tenant board closure and how backed up the LLTB will be. Has the LLTB indicated that they will be stacking up the hearings or opening any other hearing locations to get through this situation quickly?
As of right now, we haven't heard anything. I think they're behind the scenes internally trying to figure out how they're going to go about this. There are still hearings that are going on by way of telephone if it qualifies. It's not, I have not had any landlord applications by telephone. They've all been tenant applications. But given the fact that they've had to cancel entire blocks for the last 2.5 weeks, they are looking to other alternative hearing solutions. But as of right now, we don't know what that looks like.
Okay. So we got another question here. I would normally ask each student on a student a guarantor form. Is it a risk worth taking to ask for this level of compliance given the current state of economic uncertainty?
There's nothing wrong with asking for a guarantor on a lease. I mean, certainly, especially if you're dealing with student housing, they're going to school. It's very, very common. And I don't think that anybody would be penalized for continuing that practice at this particular point in time. Now, it may be a little bit more, depending on whoever is signing the guarantor form, there may be a difference or an impact going forward because, speaking generally, most of the time, if you're dealing with student housing, the guarantor is the parent. So depending on how the parent is impacted right now with finances, they may not be able to sign a guarantor form. So, but the initial practice of asking that, there would not be any penalty to continue that practice.
Okay, another question here. I don't know if I can't remember if we've covered this yet or not. As a tenant in a home that is currently for my rights with regard to allowing entrance for showings to potential buyers?
So right now, that's also a little bit of a tricky situation because unless it's an emergency, there are provisions under the Residential Tenancies Act that a landlord can go in without notice for emergency purposes. And then there's a section of the act that deals with a landlord's rights to enter a unit upon giving 24-hour notice, a minimum 24-hour notice if it falls under one of the categories. One of them is, a licensed broker or real estate agent showing a home that's for sale. The concern going forward, and one of the things I think might be an issue, is that even if a landlord gives proper notice to a tenant to do that, saying, yes, we're showing this home, there have been a lot of tenants that not only in this situation, but just sort of maintenance issues that are saying, we don't want anybody to come in because of the virus, right? And so even though the legislation says that you can't refuse entry by a landlord if they've given proper notice, again, how this is all going to play out, and I think certain considerations are going to be given if someone is saying, I don't want someone coming into my home because my family's isolated or I'm concerned about exposure. I think it's going to be assessed on a case-by-case basis. I think this may be, again, I'm speculating, but this may be, especially if it's an emergency situation, and the landlord provides a notice to the tenant because they're prohibiting them from going in because of the virus and it's an emergency and it has to be dealt with. This may be something that the board looks at to do a telephone hearing for, but I don't know what that looks like. And again, even if the tenant is not letting them in, even after you've given proper notice, certainly you can serve them with the appropriate notice for interference with the landlord's lawful right and privilege, which would be an N5 for basically not allowing the real estate agents to come in to attempt to sell the house. But in light of the circumstances going on, will the board find the tenant's actions unreasonable? And as of right now, we don't know what that's going to look like. Sure.
So Greg is asking, can I request my landlord apply my last deposit now to get a month off regular rent payments? That's actually maybe a logical solution right now.
It is, and this is something that there is, I believe that there is a bulletin on our website about that because there was some talk about that and potentially landlords being able to do that and there being a legal argument because the legislation says that a landlord cannot use a last month's rent deposit until it's the last month of the tenancy. And so any landlords that have experience at the board or have been at the board before and a landlord has done that, they kind of get a lecture from an adjudicator saying, you can't apply that. The whole intention of that is you apply that amount to the last month of the tenancy. Certainly, I think that it's something that maybe in light of the circumstances is another thing that the board is going to factor in for the parties to sort of mitigate and minimize any loss. And again, I'm pretty sure there is a bulletin about that for landlords. And, you know, from a legal perspective, Joe Hoffer of our office wrote it, and I think that it was on our website, but it could sort of set out what the approach would be for a landlord if they made those arrangements, and if it did come about down the road and there was any sort of issues, that there is information about how you could potentially argue that with the legislation.
Okay, so Samantha here has a question. If a tenant is already on government funded money and we know that they have monies that is to pay rent and refuse, can we reach out to workers?
Well, I did touch upon that earlier, and the answer is no, because unless they have agreed to pay the landlord directly from the funding, I mean, certainly you can approach a worker, whether a worker is going to talk to you about it. Again, you know, they may or may not because of privacy laws. But, you know, there are, even before this, there were certain people that were on a fixed income or subsidized income that didn't pay their rent. And it wasn't because of this. Yeah. So, you know, there are always circumstances for that. And there was never anything prior to this that required the government, even though there's a, you know, a basic rent or a shelter provision formula for subsidized housing, Ontario Works, disability, whatever the case may be, there's nothing that says it has to be paid directly to the landlord unless the tenant has authorized the government or their worker to do that.
Okay. So Cam has a question here. If you are currently looking to rent a vacant unit, are there any steps you can take to protect against a tenant signing the lease and immediately refusing to pay? That's an interesting question.
Well, there's absolutely nothing you can do. I mean, usually the normal approach when you sign a lease or rental application, you collect a last month's rent deposit. Usually you collect first and last month. Yeah. Usually you collect last month's rent deposit first, and then you know, the day of, you know, the first day of the month that the tenancy begins, you collect rent. So right now, unless you collect it up front when you're signing all your documentation and say we require first and last month's rent deposit, there's no assurance that you know, you're going to get the first month worth of rent. I mean, I think in the normal course of business, there's no guarantee of that apart from what's happening right now, right? You set up whatever method of payment, you make arrangements, whether it's e-transfer, pre-authorized payment, you know, personal checks, whatever the case may be. You know, whether they clear or not, there's nothing that you could do really to ensure that before this. So there's nothing that you can do to ensure it right now.
Mm-hmm. Okay. So question here from Will. If a landlord volunteers to defer rent, is it okay to say the deferral amount is from the last deposit account and therefore less interest paid on the LMRD?
Well, last month's rent deposit, interest is paid on an annual basis. So you have to pay that interest. But certainly I think, you know, if there's an arrangement that says rather than pay out the interest to you, we just, you know, attach it to your tenant ledger or your accounting ledger, whatever the case may be. you know, I think that will work if you're not triggering your right, and we're, you know, a landlord has the right to increase the rent by the guideline once a year. So usually what happens is if a landlord's giving a notice of rent increase, it's based on the guideline, they're also paying the interest out on last month's rent deposit, which is the same amount. They just offset one another, right? So rather than pay out interest to the tenant, you top up the last month's rent deposit. Mathematically, it's going to work out, but you know, this year the interest and the guideline is 2.2%. We're not talking about a significant amount. Last year it was 1.8%. So certainly there's nothing wrong to have that agreement by saying, you know, on a go forward basis, we're just going to credit your interest payable to you on your ledger, or offset any monies outstanding if that's agreed to by the parties.
Okay. Question here from Gord. Hi, it's Gord from Rembrandt Property Management. Would you recommend using an L9 form to come up with payment arrangements with a tenant, or is it equally valid to just come up with a written agreement between the tenant?
Well, it really depends on what you're looking for. So, I mean, if you're looking for just an order for the arrears and you're not looking to terminate the tenancy, then again, you can certainly file an L9 application. Right now, you don't know when you're going to get a hearing date, okay? If you file an L9 application and once it's been processed, it gets a file number. So if you're looking to have sort of a concrete order from the board for non-payment that has nothing to do with termination of the tenancy, once you've got assigned a file number, there is a form on the Landlord and Tenant Board's website, which is an agreement to payment plan. And after you've filed that application, and I believe that you probably can do it for an L1 application too, which is arrears and termination, but there's going to be no termination component to this order at all. So, you know, one, you can enter into a payment arrangement for the tenant right now, stipulated template, have that communication, or you can file an L9 application, but who knows when you're going to get a hearing date, what that looks like. And once it's been processed and the board's given it a file, there is an actual board form that you and the tenant can sign setting out a payment plan, and the board will issue an order. If the tenant doesn't adhere to that payment plan, then it actually goes back to a hearing once it's up and running, but there's, again, no termination component to that.
Okay, so Nick has a question here. If a tenant is in breach, or is a tenant in breach if they do not pay their rent tomorrow, and can I give them 60 days to vacate and list the property?
No, you cannot. So if, as far as landlord and tenant relationship is, a landlord cannot ever just give 60 days notice for the sake of giving 60 days notice. The landlord in the province of Ontario can only give a notice to terminate a tenancy based on a prescribed notice of the board. So if you want to terminate the tenancy based on non-payment of rent, you have to give an N4 notice. And as of right now, as I said, the board's not issuing eviction orders. We don't know when you're going to get a hearing date. Now, if the parties are voluntarily agreeing to terminate the tenancy, there is a form. It's an N9 form. All the forms are available on the Landlord and Tenant Board's website. Every form, there is instruction information. That's the very first page that will walk you through the form itself. Certainly, you can agree with the tenant to terminate the tenancy, but a landlord could not, because the tenant doesn't pay rent tomorrow, turn around and just give 60 days notice. They have to do it on a prescribed form of the board if they want to terminate the tenancy.
Okay, so Krista here has a question. Just to clarify, if a tenant is receiving financial support from OW or ODSP, is a portion not allocated to shelter
Absolutely.
couldn't be reported.
There is a portion that's allocated to shelter. You know, that's based on how the government sets out how much they're entitled to based on OW, whatever their household is, who resides in their household. They have their own amounts that they pay out, and a portion of that is factored in for shelter. Sometimes the entire monthly rent is not covered by the amount that they get paid based on their household income. But you know, again, I indicated that there were people on financial assistance prior to this happening that didn't pay their rent for whatever reason, and you know, some were legitimate reasons, some were unforeseen things that they needed funding, whether it was for medication or something else, and some were, you know, they just didn't pay their rent. But there's nothing that is a landlord can do by contacting a caseworker that says, you have to pay the money directly to me because some of it is based on shelter, unless the tenant is authorizing the caseworker to do so. So if you're aware of somebody who's on financial assistance, you know, maybe when you have that open communication with them, maybe that's a topic you have by saying, you know, why don't you, so you don't have to worry about it. You can certainly reach out to your caseworker to have them pay monies directly to us. It'll be up to the tenant whether or not they agree to that and whether or not they authorize it. The other component to that is, even if it is authorized, if it's right now they have money being paid directly to the landlord, or afterwards they authorize it, they at any time can contact their caseworker and say, I want all my money to be paid to me first, and stop that, because it is, you know, it's up to them essentially. Unfortunately, there's no mechanism or anything put in place that those monies, based on shelter and how it's allocated, that they get directly paid to the appropriate landlord, utilities, whatever the case may be.
Okay. All right, Shannon, I think we're going to wrap up now. I mean, we've been going for over an hour.
Wow.
Yeah, it kind of flew by. So hopefully we answered everybody's questions. If you do have any other questions, where could people kind of, I guess, reach out and find you if they did need some help of some sort?
So on, again, our website, cohenhiley.com, there's a link to all paralegals, all lawyers in our office. If you click on my name, it will give you my email address, my phone number, all of the relevant contact information. So you can reach us at that point through that website. And then, as I indicated, a lot of the articles that have been written about what's been going on and how it's impacting not only tenants and landlord, it's all available on Cohen Hiley's website as well. So there's, you know, we have an entire team that deals with this area of law, and certainly our contact information is available on the website. And also, I would encourage anybody to go onto the Landlord and Tenant Board website, because they are posting their status, what they're planning on doing, when they're going to be up and running, information as well. So those are two very good resources available to people right now.
Fantastic. Awesome. Again, thanks, Shannon. And maybe as some more developments come and we get, I guess, some more information, maybe we could get you back on to talk.
Absolutely. Sure.
So again, thank you everybody for tuning in. Again, if you have any other questions, feel free to shoot us a direct message, comment on our Facebook or any other social platforms. If it's more of a private question or something and you don't want to be as in, the whole purpose of this is to try and bring as much information to everyone, because we're in uncertain times right now, and I think more than ever we're all confused. So thank you everybody for tuning in, and thank you again for agreeing to do this. It's been a blast.
Thank you so much.